Jay McDaniel. Today's topic is on the somewhat technical but pretty important issue of what the effect is of securing an incontestable trademark. Incontestability is the status that a trademark will get after a certain amount of time. The way the process works is that you register the trademark, it gets approved, published, and becomes finalized, and then there's a period of 5 to 6 years during which it has to be in use. And between the 5th year and the 6th year of use, the owner of the trademark can file a statement of use, at which point the trademark becomes incontestable. What does that mean? Does it really help the trademark owner if there's a dispute with another party? And the short answer is it may help a little bit in some districts, but in other places it doesn't matter at all. And the reason for that is that in trademark litigation, you either have to show that there's a likelihood of confusion, that somebody is going to misidentify a good or service. Because remember, what is a trademark? A trademark is an identifier about the source of something. Gucci has a well-known red and green stripe design that they apply to certain things. Other people have tried to use red and green stripes to sell other types of fashion. Red and green belongs to them. People who see red and green think Gucci. In looking at the question of whether or not there's a likelihood of confusion, the courts will go through a whole list of factors. And one of the factors, and arguably one of the biggest factors, is the strength of the trademark. And so there's been a great deal of dispute over whether the fact that a trademark has become incontestable should factor into this analysis. Is an incontestable trademark stronger than another trademark that simply hasn't become incontestable yet? You have one group of courts that hold that the incontestable status of the trademark is entitled to weight. It's entitled to be included in the determination of whether or not it's a strong trademark. There's another set of courts that say it doesn't mean anything. It just means it only determines whether or not a party owns the first right to that trademark, and the question of whether or not there's been confusion and how strong the trademark it is a question wholly separate and distinct from the issue of whether or not the trademark is becoming contestable. Trademark Trial and Appeals Board recently, in a trademark registration dispute, came down on the group of courts that say it doesn't matter, that incontestable status does not factor into a determination of whether or not the trademark is strong. You can have incontestable trademarks that are weak. You can have trademarks that haven't become contestable yet that are strong. So where does that leave us? You certainly still want to register your trademarks. You still want to own your trademarks. You still want to police your trademarks. Relying on the incontestable status as evidence of the strength of the trademark is probably not a great idea. What you would be better advised to do is to have an enforcement program, to have quality controls, to really build the trademark through its strength, through its unique identification, through the fact that it stands for a particular product and a sort of a level of service and a quality of goods. All of those things are likely to be much more valuable in the end than relying simply on whether or not the trademark has become incontestable. That's all we have on this subject. Thank you very much, and please feel free to contact us if you have any questions or comments.